The order of adjournment. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine SCAO form MC309. SCAO for State Court Administrative Office, MC309, that's the form number. And you can see from the yellow arrow in the bottom left corner, the identifying form. This form is available for free through our website. We'd be happy to give you a copy. With all of these SCAO forms, they are created by various court rules and or statutes. In this case, the controlling court rule is Michigan Court Rule 2.503. This court rule identifies the bases for requesting an adjournment. What is an adjournment? It is a request for a hearing or a trial to go to a new date. So there's a hearing date or trial date that is on the court's docket, and there's a request and then ultimately an order that identifies or assigns a new hearing date or trial date. That's what an adjournment is. So there's a hearing date, it gets adjourned to a new date. This particular process can occur in various courts, circuit court, criminal court, but we're going to speak of it from the context of probate and trust-related issues. So the same SCAO form is used in the probate court, and if you can see from the top left corner where the blue rectangle is, that's the county in which the court matter is proceeding. Top right corner is the case number or file number for the court matter. This could be a guardianship, conservatorship, probate administration, etc. The top section identifies the case heading of the matter upon which the adjournment may be involved. So you can see it says people of the state of Michigan. That refers to a criminal matter. Plaintiff and defendant, that would refer to a civil action. But then you'll see a little checkbox where it says probate. That would relate to a probate proceeding in the matter of the name of the person upon which the matter is proceeding. It identifies the petitioner or plaintiff's counsel information if one exists, as well as the defendants. Now the court rule says that upon good cause, the parties can request an adjournment, and that stipulation or agreement to adjourn can occur, as well as the court can do so on its own motion when good cause exists for the hearing date to get moved. So the court finding is this next section. Somebody has moved or requested. Moved means you're making a request for an adjournment of a trial or a hearing. And that request, that with a present set date, and the date would identify there with the name of the judge, the referee, the magistrate, and then the court enters an order. It is ordered that the trial, hearing, etc. is adjourned, and then the new date and time. Now, this particular form doesn't have the stipulation part or the petition part. So the request for the adjournment would occur on a separate writing in the form of an agreement, a stipulation for an adjournment, or a motion or petition requesting that the adjournment occur. This is the ruling after that petition has been made. So there's a request made, and then an order gets entered. Now, this form also gives some room for the court to identify the reasons or the bases for the adjournment. For example, maybe there is a party that has passed away, has died, or is not available on the particular date. Those would be some reasons that the court may identify in that reasons section. In addition, the court can also order that there are costs assessed, because there are costs associated with the hearing. Maybe there are witnesses that need to be that are being paid to come to the hearing, and the court assess costs as it relates to the particular adjournment. It's not a mandatory section. This is an area where the court can have that as part of the court order. And of course, in item 3, where the checkbox is, the court can simply deny the request. So remember, request made, and then this is the order. And the court, as we say, speaks through its court orders. Now, with all of these types of matters, court rules, statutes, they can be quite complicated. And of course, lawyers go through law school to understand the full breadth of these statutes and court rules, as well as the lawyers that are commonly practicing in that court understand how to apply the statutes and court rules in the particular matter. So we urge you to work with a skilled, competent probate lawyer as you're making your way through a particular matter. At the Probate Pro, we are passionate about everything probate. If you have a question about the order of adjournment or any probate or trust related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.